pass the buck when they're all in and stuff. Welcome,
Jennifer,
everybody.
Time.
Wow.
Welcome, everybody. We're letting you in. Please make sure to keep your microphone and your video on mute. There will be some impromptu networking after the presentation is complete, but for now, please make sure to keep your microphone and your video on mute. We are going to be getting everyone in for about a minute and a half, 2 minutes, just to give people some time to get on, and then we will begin. Sorry, you guys can talk again if you want. I have to do my spiel.
Maybe we should have rehearsed some, some hold music, some elevator music we could hum. Well,
I just wanted to say hi.
hello.
Wendy just wanted to say hi.
Yeah, you will not be seeing me. I'm currently in a swimsuit. That is unacceptable.
Ooh, now I want to see you in the swimsuit.
No, hell no. That was cute 20 years ago, honey.
I'm sure you're gorgeous and beautiful just as you were then today.
Oh, you are, Becky, I never knew you were such a good liar. I love you.
No, whatever, Wendy.
Going back on mute.
Thank you. Hi, everyone. Welcome in. We're going to give a second to get everybody else who is signing on right now in, and then we will begin. As always, please make sure to keep your microphone and your video on mute. There will be some impromptu networking at the end of the presentation, but until then, please make sure to keep your microphone and your video on mute. We are recording this program, which will be said again later, but we are recording this program. These programs do get cut down and put on YouTube for viewing later. You can only get continuing education credit, however, for being here at the program. So woo you! Please also make sure to change your name to your actual name for attendance purposes. So we're going to give people about another minute, and then we'll get started.
Christy Hoover says she can't hear a thing.
Is anyone else having hearing problems?
Christy,
in the chat?
No.
Okay. Okay. It could be. Christy, try call it. Oh, she can't hear.
She can't hear.
Say it louder, Rachel.
I know. This is my day-to-day, man. I only had one cup of coffee. That was a problem.
We need to give you more coffee then.
Rachel needs more coffee. Yeah. All right. I think we got all of the weight room in. All right. I'm going to hand it over to Jen.
Hello, everybody. Welcome to our second digital education program. Super excited. My name is Jennifer Richardson. I am the president for your CAI California North Chapter for 2020 only. I'm not sure how many board members we have in attendance today, but I just want to give recognition to all of them because they are doing such an amazing job through all of this. So John Hanson, Scott Hubbard, Mark Glassberg, Miranda Ward, Richard Navarez, Dan Young, and Jeff Brown. So thank you to all of you guys. The board is spending a lot of time making sure that we're communicating with you guys during this time, and if you have any chapter questions, please feel free to reach out to any one of us. We'll be happy to talk with you about anything. Of course, none of this would be possible without our event and sustaining partners. So we would like to give a special thank you to those partners that have donated their sponsorships for events that could not occur during 2020. And I believe that Rachel has those on a slide coming up for you.
Oh.
And we're also going to let our event sponsors have just a couple of seconds to say hello to you. So if you would introduce yourself when I say your company name. Allied Trustee Services.
Hi, I'm Stephen Murphy with Allied. I'm in our Roseville office. We're very proud sponsors of many chapters of CAI in California, and we're especially happy to be a leader in assessment collections in the state, returning over $19 million to our California communities in 2019.
Wow, thank you, Stephen. CAM Construction, Dawn.
Hi, everyone. I'm Dawn Batchelor with CAM Construction and Painting, and we're super happy to be a sponsor today. We are fully open and operational, so any work that your communities are getting ready to do, please give us a call and we'll get working for you. Rachel, Dawn Robinson needs help logging in.
Thanks. I just sent her the information.
And unfortunately, Allie with Mission Landscape could not be here today, but they are also an event sponsor, and we certainly want to give them recognition and our thanks. So thank you, sponsors. We appreciate you. And of course, the other rock stars are our registration sponsors, and today's registration sponsors are Badallen and Jacobson, Pacific Western Bank, and Seacoast Commerce Bank. So thank you to our sponsors, and we ask that you all please consider them when you are planning your projects or need help in your community. So, okay, on to some housekeeping. Rachel, you have a slide.
Do you have a slide?
We are recording this meeting, and it will be available for YouTube shortly after the program. Please keep your microphone and video on mute. We will be taking questions via the chat function at the bottom of the Zoom screen. And we did receive some questions in advance. We will also be addressing those questions at the end of the presentation. So finally, anyone who misses seeing all of the lovely faces of our chapter members, please be sure to hang around after the session is over, because we're going to have an impromptu networking session. So make sure don't sign off right away. You'll be able to turn on your camera and your microphone and have a little bit of socialization. So now on to the program. Today is Collections Forecast, what to expect as the pandemic continues and what you can do to help protect your communities. It's being presented today by Becky Jolly of Omni Community Management and Stephen Murphy of Allied Trustee Services. So take it away, Becky and Stephen.
Thanks, Jennifer.
Thank you.
Becky, if you want to introduce yourself while I get our screen set up.
Yep. My name is Becky Jolly. I'm with Omni Community Management. I've been a certified manager through CACM since 2007. I enjoy communities. Mostly my passion projects are probably my cooperatives. Stephen, I'll let you take it away now.
Thank you, Becky. My name's Stephen Murphy with Allied Trustee Services. I've been with Allied, I'm one of the newcomers on the team here. I've been with the company just coming up on 3 years. I come from a background of compliance and sales in the financial services industry. So I managed financial advisors over Western states for one of the country's largest independent brokerage firms. So that's the majority of my career is the compliance of investing, which is sort of what got me into working into assessment collections, because certainly there's a lot of compliance involved with this industry. So Becky and I have put together a program that we hope you find interesting. We know in these Zoom meetings, it's a little more of a challenge to make it feel interactive, but there's the chat window. I know some of you submitted some questions to Rachel earlier via email, so we'll get to those at the end. But during the presentation, if you've got a question, go ahead and post it to chat. After a couple of them come up, Rachel will pop in and let us know that we have a question. Becky and I will try to address it right then. If I can just ask, if you submit a question that Becky or I are going to get to a little later in the presentation, if we can ask you to hold on to that, and we'll work it into maybe where we're already going to kind of head in the direction of the meeting. We've designed today's overall topic so that we can talk about the law first. There are a lot of laws that govern collections. Some of you may be very familiar with them because of your experience with your own communities. Some of you may be unfamiliar because either you're newer into the industry, or maybe you've been fortunate enough to have communities that don't ever have collection issues, which certainly happens. We're also going to talk a bit about how the COVID-19 pandemic is impacting us right now. Some things that we foresee in the very near future, such as legislation that's either pending or may have already passed, or executive orders maybe coming out of the governor's office. All of those things. I'm going to touch on some pending state legislation and a couple of federal bills that could really impact us pretty heavily. In fact, I've asked our general counsel here at Allied to send me a text during the meeting. There's one that Becky and I are following pretty closely. It's a pretty big bill. It has the potential to really impact communities in a negative way during an economic downturn. And there's a chance that it might actually go up for vote while we're in the session. So if you see me looking over at my text message, it's, I'm not actually texting with my family or friends. It's looking to see if that bill is passed. Then Becky and I are going to talk about some case studies. Certainly, even in my 3 short years in this industry, I've seen some things that communities could have done things differently to help protect themselves. And certainly with Becky's experience, she's got a lot of experience in things that communities could have done differently. So we've got 3 brief case studies that we'll talk about. Then we're going to go through, at the end, we'll go through a checklist of things that you and your colleagues can do with your communities to check to make sure that, you know, are there some roadblocks that we can avoid or set aside as we look to a potentially deteriorating economic market and housing market. And then that last item, that checklist, when the recorded presentation is made available to all of you, that checklist will be available as well. So you could share it with your colleagues in your offices or on your teams that maybe weren't able to log in today. So I think I captured everything. Becky, does that sound about right?
Yeah, the checklist is also to have an early discussion, because one of the things that did happen when the crisis back in 2007 going into 2008 up until, you know, just a few years ago, because people were still digging themselves out of a hole, is talk about things in advance, plan things. You're going to be starting to look at your budgets, or at least I know I start looking at them in July, and where I need to start getting guidance, make sure I'm getting bids, proposals for the items for next year, and anything we couldn't complete this year. That's the time to really look at this checklist and really have these open and honest communications with your boards, which can be difficult.
I've put up a slide with our contact information. So after the presentation, if there are additional questions, anything that Becky or I bring up, we both want to encourage you to reach out to us and shoot us an email or give us a call. You'll see our contact information will come up on the slide at the end as well. And with that, let's get into the ever exciting topic of the law. So there are federal laws that cover collections, and that law is really designed around consumer protection. Laws get made when there are bad actors. You know, when someone does something that is just beyond what's acceptable, and so state or federal legislature will try to create laws that restrict that behavior. Certainly, collections behavior. You know, there have been reports, you may yourself have heard of friends or family members in the past who, or neighbors, who just get, you know, bombarded by debt collectors and credit agencies and mistakes and errors that are made that affect people's credit ratings. So laws are in place to help protect consumers. And so that means then that we as a collection agency certainly have a very well-defined set of parameters, a sandbox, if you will, and we have to stay within that sandbox. And so on the federal level, that is the Fair Debt Collection Practices Act, or FDCPA. There is then, and that law even dictates the font size of the letters when we write correspondence to debtors. And Allied has been challenged on that. We had a very angry owner. They certainly weren't objecting to the debt that they owed, but they were just so mad they were trying to come up with something. And so they took us to court and said our fonts were too small. And we went to court and the judge got his ruler out and ruled against him. So.
And this also dictates what goes on the outside of the envelopes, because I know that some board members are like, well, just, you know, final notice, stamp it on the outside of the envelope. FDCPA says you can't do that. You're not supposed to publicize someone's debt in any way. So you can't stamp things or stick things on the outside. You can't change colors because that's publicizing a debt.
Yeah, if somebody sees that envelope, then it's sort of the equivalent of HIPAA, not being able to share medical information with anybody who isn't involved in my healthcare. It's to protect me. And the same with FDCPA. Yeah, they don't want final notice stamped on the outside of an envelope, because if someone sees that, who's not me, now that person knows something about me that they shouldn't. So it's the rules are really, really tight, and there's some legislation pending that's going to potentially impact that. The next one, the Rosenthal Fair Debt Collection Practices Act. That is California's version of FDCPA. And what's of importance in the Rosenthal Act is that it extends the rules of how you behave as a debt collector to property management companies and homeowner associations.
Yes.
So that's why most property management firms are not in the debt collection business. And certainly homeowner associations need to be very careful about making phone calls to owners, because we go back to the FDCPA in the state that dictate what can be said, what can be left on voicemail messages, what numbers or emails we can send communication to. It's very tightly controlled. And then of course, Davis Sterling. The component for us is just really I think it's the 5600 series within Davis Sterling that created the streamlined and much less effective non-judicial foreclosure path for community associations. That section of the Davis Sterling Code is what allows Allied to offer that non-judicial pathway so that a community doesn't have to go to a law firm and go to court to do judicial foreclosure, which is nearly always significantly more expensive and it takes a longer time. There are absolutely times when a judicial foreclosure is necessary. There are some interesting, and it happens in California, especially if we have foreign owners. But we can talk about that when we get to another change in the law potentially.
And then just for those who have cooperatives, if you have a mobile home stock cooperative that is under housing and community development, please remember that you don't have foreclosure options, that you do have to go through the eviction process, which you may have to do with HCD depending upon your county region.
So I know that's one of Becky's passion projects. And so any of you that have those co-ops in your practice, make sure you've got Becky's contact information if you don't already, because she's a valuable resource for you to reach out to in the future. And I know that's one of her passions. In addition to the laws that are already in place, there are some significant court cases that have defined the law and have actually changed how the collection business in California operates. And this is important to know because we get a lot of questions from clients who are being prospected by out-of-state firms who clearly don't know the law in California. Some of these apply nationally, though. The Goodalock case, that was, gosh, a year and a half ago. That is an important bankruptcy case because the case states that an owner's personal obligation to pay ongoing assessments is discharged if they successfully complete a Chapter 13 bankruptcy plan. So they get their 60 months, they're making payments to the association, they're supposed to be making their current assessment as well as chipping away at the debt that they've incurred. But when they get to that 60th month, if the trustee says, okay, you've completed your plan, your debt is discharged. Goodalock, which went to the Ninth Circuit Court of Appeals, says, all right, your personal obligation is discharged. That's a problem here in California. If we want to change that law, we've got to get the legislature to change it, or one of us is going to have to go to court to change it in a court case. We still are protected by our lien rights. So the debt of someone who's come out of bankruptcy, if they stop paying their assessments, the court says they don't have to, they're not personally obligated, but we still have lien rights. We can still do the lien to foreclosure process in California, but personal obligation has been discharged. In the DeGillen case, this is the one that was just this last year. This is significant because the court is aware of what's happened. DeGillen allows a bankruptcy trustee and this is only applying in bankruptcy, it allows the bankruptcy trustee to take a look at the lien that we have recorded. And while our industry operates on the understanding that a delinquent assessment lien is a continuing lien, meaning we placed it 2 years ago for $2,000 in debt, and that owner continues to not pay. So when we get that escrow demand, we're going to tell the title company, here's the full amount that they owe right now. The bankruptcy trustee is only going to look at this amount that we filed 2 years ago or 6 years ago. And that's it. They're not taking what that owner owes between the date that we filed the lien or recorded it to protect that debt and today's debt. That's a problem. And if I can read something that the court actually wrote in their decision, the court acknowledged and dismissed the additional costs to owners, because now what associations have to do is apply multiple liens. Here at Allied, we look at files that have been with us for a while, and we look at a couple of things for red flags. How old is that lien? And also, how much has the debt increased? If the community has a very low annual assessment, maybe it's a rural community, and it's just a few $100s a year, then we're probably not going to put that high on the list for slamming a new lien in there, because it's a lot of fees and costs. But let's say you're a high-rise in San Francisco, part of a luxury hotel, and the owners have access to all of the amenities in the hotel, and your monthlies are, $4,000 a month. For those, we're very likely going to be placing a new lien every year. And the court said, while we acknowledge that requiring HOAs to file successive liens imposes a burden, that is an issue for the legislature to address. So very plainly, the judges knew what they were doing when they wrote this, but they're interpreting the law. The Ninth Circuit doesn't make law. They're just reading the law, and they're reading how it is impacted by other laws, and they make a clarification. So it's important to look at how old liens are and how much the debt has grown. And it's really just a risk of bankruptcy. The next three cases were court cases, probably 2014, 15, and 16. Cisneros was a bankruptcy case, and Cisneros and Hansen and the Hansen case together clarified that associations must incur the cost of debt. They effectively eliminated in California what all of us as collection agencies, Allied included, that we had no fee, no cost contracts, meaning you'd send somebody to collections, and if Allied was not able to collect, we're not sending an invoice to the association. We're just going to pursue that debtor. The Cisneros and the Hansen versus Pro Solutions case clarified that the association must incur the cost of collections. So the collection agencies here in Northern California, for the most part, we practice deferred invoicing because we typically collect from owners. I have found that most Southern California attorney-connected law firms or attorney-connected collection firms, they bill as they go. So there's always an invoice in your inbox every time you call them to ask for an update or something. And another important part about that distinction is that a lot of out-of-state collection companies, they don't really understand that. So we get a lot of confused board members calling us saying, well, these people are saying there's no fee, no cost. Like, well, that's in other states, that's the case. But if you send business to them, you're putting yourself at risk with a company that doesn't understand the intricacies of the law in the world's 5th largest economy. And maybe they should spend a little more time understanding how California operates. And then the last one, Huntington Townhomes, has to do with associations being required to accept partial payments. In the past, an association could reject a partial payment. You have a debt, the total amount is due. And if you don't pay the total amount, we're going to proceed to foreclosure. This lawsuit at Huntington Townhomes the association board president accepted a cashier's check for about $3,000, which was a significant portion of the debt, from the owner. And the board president said, "Thank you, I'll get this to the collection company right away." The collection company decided, "No, we're not accepting that. We're moving forward with foreclosure." They foreclosed. They went to court, and this case pointed out that you have to accept payment, even if it's a partial payment. But the Huntington Townhomes is also what helped Allied create our payment plan agreement, which includes language that when a partial payment comes into your office or our office, we're required by Davis Sterling to apply those amounts to the oldest assessment debt. And so if you imagine that there are two columns, $2 amounts that an owner owes. They owe assessment debt, and they owe fees and charges and late fees, interest, and Allied's, the collection costs, or any collection company's collection costs. If they keep making random partial payments, they may eventually pay down the assessment debt. When that happens, Allied and any other collection company, we have to close the account because they no longer qualify to be in collections. They don't have a sufficient amount of assessment debt. When an owner enters into a payment plan agreement with us, they are signing to a particular clause that says when they make partial payments, those initial payments go to fees and costs and interest charges and collection costs first, so that if they default on that plan, the full force of your lien is still in effect. And that's critical to know as we move into a discussion about what's happening in the economy right now, and the potential for foreclosures. Becky, I would imagine that you saw a lot of payment plan requests in the last economic downturn, and I think that's probably an activity we should see again.
So a lot of homeowners actually just put their head in the sand, and that's what you're going to find. They're embarrassed, and that's going to be the hardest discussion that you have with homeowners and board members. And I've had board members who were delinquent. Having those executive session discussions with them, talking to the homeowner, and you can be the big bad wolf. I know I love being that, but you also have to do it with compassion. You have to understand that, yes, you're going to get them and their little dog too, but there's also a line for, okay, this person really is truly struggling. If someone wasn't struggling, if they were blowing off their assessments before this happened, I'm less inclined as a manager to fight for them versus someone who legitimately did just start having issues. Someone passed away because of this. Those are probably going to be, I'm going to be more compassionate for someone in that circumstance. And you have to remember that compassion is part of being a manager, even when you don't want to give compassion because this homeowner is one of your most annoying persons. You have to give them compassion. You have to give them grace and space, just like you've been given grace and space over the last few months. And talk to them and just know you're not going to look at them negatively. Just tell them, hey, you know what, I understand that you had this bad thing happen to you. I can relate. And if you have something and you're comfortable sharing what you experienced as a human, share it. Let them know that you're just as human as they are and you want to help them and you don't want to treat them as though they're a second-class citizen, as though they don't have any value because now they're not taking care of their obligations that they agreed to when they purchased in the community.
I like that phrase, grace and space. I'm gonna write that down because I think that's an easy one to remember, and yeah, that's good. I like that. And so we're going to talk a little bit more about what to do with payment plans. But I think a key takeaway here is when they're in a payment plan agreement with the collection company, we're looking to make sure that we've got that lien recorded and the strength of the lien is protected so that as they make payments, if they're going to default, we want them defaulting on interest charges and late fees and things like that. And we'll talk about interest fees and late charges in just a moment as well. Let's get on to how the pandemic has affected us already. So just since we've been in this issue here, at the federal level, bankruptcy protection for Chapter 13 cases, even if they're already in a Chapter 13 case, they can extend it now from 60 months to 84 months. So we've just gone from 5 years to 7 years. How that can impact you and your budgets is if you've got those bankruptcies right now and you're getting from the bankruptcy trustee regular amounts, those amounts may drop. Because the bankruptcy trustee is going to give consideration to someone who says they've been impacted by COVID-19. In the rules that have been updated, all they have to do is sign an attestation that they've been impacted negatively by COVID. They don't actually have to prove that they're jobless or anything like that. They just have to say that they're impacted and they can get this. So something to keep in mind when you're looking at your budgets, and if you have any debtors that are on Chapter 13 bankruptcy payment plans. FHA and HUD-backed loans have had for a couple of months now, several months now, they've had a foreclosure moratorium. Just yesterday, that moratorium was extended until the end of August. So while that doesn't necessarily impact you in a negative way, it does inform that there are lots of voices out there talking about moratoriums and making sure that people are paying attention to, again, consumer protection. If you've been impacted, let's see if we can't get you a little bit of a break. So we see in the news all the time about the banks and are they giving accurate information to lenders about forbearance programs, and some forbearance programs are really bad. You know, they're looking at a balloon payment like, fine, we'll cut you some slack for 3 months, but then you owe all 3 months mortgage at once. And so there's a lot of banks are creating better forbearance programs because of all the negative attention they're getting. At the state level, we're looking at the courts that have been closed or severely limited in what they can do, and I'll touch on that in just a moment. Statute of limitations has been tolled. Tolling means it's like a pause. So if a clock is ticking on a statute of limitations that's 4 years, and we're, let's say, 2.5 years through that, tolling means that because the courts aren't open and plaintiffs and defendants can't act, that they're putting a hold on that chunk of time. So for however long this emergency lasts, that's a chunk of time that will then be added to what would have been your statute of limitations deadline. So that's very good news for us in protecting our communities, because we may have some cases that are just sort of pressing and we're getting a break. Major lender voluntary 90-day foreclosure moratorium, that is set to expire June 30th. That is likely going to continue, certainly for PR purposes. If I were running a large bank or a small bank, I would take a serious look about continuing my moratoriums that I may have. And judicial foreclosure complaint filings are suspended. So for those communities or individuals that are looking to process judicial foreclosure, that's not happening right now. On the local level, there are cities and counties that are starting to create certain stop measures, which is fine. Localities should have control over what's happening to their renters and homeowners in their communities. And if they need to be a little more on the ball or take action because maybe the state hasn't, then they're going to do that. It means that when Allied is going to, or any collection company, but specifically Allied, when we're going to be moving forward on any of your foreclosure cases that are with us, we're going to check to see what is that municipality doing, because the state may be ready for us to move forward with a certain step, but a city or a county may have said, no, don't. And right now that's San Diego and Orange counties. We're already not doing anything as a state, but when we start back up, we're going to look in particular at those. And Rachel, you've got a question?
I do. I have a question for you. So if an owner is not in a payment plan and they pay little by little, they could escape having to pay the extra fees and interest completely, and then the HOA has to absorb it. But if they are in a payment plan, then those fees and interest are included. So why would a person want to enter a payment plan?
Not quite. So when an owner, so we'll go back to those two columns. We've got the assessment debt and the fees and costs, interest and late charges. If the owner is just making random partial payments and they pay this debt down, and now all of a sudden they no longer qualify to be in collections, collections companies will then send you an invoice. You have to pay that invoice, and then you apply all of those fees and costs to the owner's account. There is no enforcement by foreclosure for fees and costs, but they are still obligated for that debt. And if that delinquent owner falls delinquent again, which history shows that that is the typical behavior, then when you send that account back to a collection company, you will send it back with all of those fees and costs already in place. And the account will start again. It is time consuming and frustrating for boards, but it is unfortunately how the civil code works in California. Becky, did you have any comments about partial payments?
Yeah, so in your collection policy, and please make sure that you have updated your collection policy, had it reviewed by your attorney, because you have to make sure you've changed everything, especially I've seen some collection policies that still say you can't accept partial payments. You need to make sure that those are updated. And just because you send someone to collections doesn't mean that they're not liable for everything that is in your collection policy. So if your collection policy says the interest rate is maximum amount allowed by law, currently that's 12%, then 12% per annum, then they're required to pay that. Same with late fees. They don't get to have an excuse, well, I only get those if I go to collections. They have them regardless. That is the collection policy. That is what you send out in your annual disclosure. This is why you're telling them up front, you are required to make these payments. If you do not, here's our policy of how we're going to handle it. So that doesn't change anything just because you're in collections or not collections. They're still required to pay the interest. They're still required to pay the late fees. The only way that they can have them waived is if they write a letter to the board and the board says, okay, Sally Mae, you have paid all of your assessments. We didn't put this in our budget and we're not relying on it for income purposes. So we can now waive these items.
Thanks, Becky. And to whomever asked that question, I hope that Becky and I were able to address it to your satisfaction. If not, if you've got a follow-up, post your follow-up question, because I want to make sure we get that answered for you. Yeah. Continued impact currently, mortgage delinquencies are on the rise. Although interestingly, March is historically the lowest in new mortgage delinquencies, mostly because homeowners are able to tap into any tax refunds that they might be getting. So I thought that was an interesting piece of trivia. Unemployment rates, however, are fast approaching the Great Recession levels. And then of course, for those of you who happen to follow unemployment levels, you'll know that the number that was announced in May was immediately followed up with, oh, that is terribly inaccurate. And you can get the better numbers from news sources that caught the mistake. Assessment delinquencies are beginning to be on the rise. People did get tax refunds, many, but if they didn't get that tax refund until they were in the shelter in place, they might not have been spending it on a delinquent assessment debt. HOAs are already receiving forbearance requests from owners. And then of course, for budget items, you very may well have additional costs, whether they're cleaning costs or security or closures that are related to the pandemic and the shelter in place. So pending legislation. A couple of these are quite possible, and a couple of them are just not likely, but you may see some reference to them, or for those of you that are kind of policy wonks and you want to get into this stuff, we'll go quickly through it. At the federal level, and I'd sent out a constant contact to people on our list little over a month ago, even with sample letters that you could send to your representative in the House and your state senator about these bills. Senate Bill 3565 and the House 6379, and or in the HEROES Act. They're looking to change FDCPA. So let's enter our Wayback Machines about 20 minutes ago when we talked about the federal law that rules all debt collection, not just assessment debt, but all debt collection. They are looking very plainly at fundamental changes in enforcing a lien through foreclosure, and it's prohibiting Allied, but it's also prohibiting, by extension, management company and the homeowners association from proceeding with any lien to foreclosure, non-judicial or judicial, until 120 days after the emergency order is lifted. So that's 4 months after the president says, all right, this pandemic is over. We don't know how long that's going to last. Taking or threatening to take any action to enforce collection. That means even correspondence, which extends to late or delinquency letters. We wouldn't be able to send those. This act is very, very prohibitive. Suing or threatening to sue for non-payment, garnishment of wages. We can't even do that right now with the way courts are closed. They're not accepting wage garnishment requests from Allied, so we're not even doing that. Charging late fees and interest to past due balances of any kind. So that Becky's point about making sure you're not counting on interest and late charges as part of your HOA income. This is one reason why, because it's possible that it could just be wiped clear. And then, of course, I mentioned sending late notices. This is pretty impactful, this legislation. On the state level, by the time the state was, our assembly members and our state senators were due to come back into session at the beginning of May, there were over 3,000 bills that had been accumulating since the first year or since last session. Just to give you an idea of how much they have to wade through. On a positive note, I saw that there is a committee within the legislature that is recommending a permanent change to the teleconference rules for common interest developments in particular. And I know, Becky, you saw this too. This was just yesterday, I think. It came out of committee, or maybe 2 days ago. So it's not just the ability to have teleconferences, but sort of codifying that it doesn't just have to be this pandemic. It could be any emergency, that we want to give common interest developments the flexibility to not have to adhere to the rules that are already written into code.
What it means, just to kind of touch on that a little bit more, is that normal operating rules, you can have teleconference, but you need to have a physical location and someone where you can interact in a two-way function, so they can hear and they can respond during open forum. Right now, we're not required to have a location, and what they're talking about doing is extending that for any other emergency. So like when the campfire came around, if something like that's happened again, where we have a huge fire, they don't have to have a location, because obviously it's a fire, everything burned. They can then have a meeting online without designating a location, because it is a declared emergency.
AB 828, it already looks like this one has failed at the state level. It would prohibit non-judicial and judicial foreclosures through the duration of the declared emergency with a sunset of January of 2022. And so that was really looking like a very long period of time. The next big one that we'll talk about is even worse, but this one was just poorly written. On a positive note, the topic of remote online notarization, it was defeated here in the state. It never got enough votes to pass. However, there's a federal Senate bill that is looking to modernize electronic notarization of documents, which I think we can all agree would be great. So that's a little piece of positive news, right? SB 1148 removes the requirement of publication. This is an expensive piece of the non-judicial lien to foreclosure process. It's expensive for the owner because they're the ones that are going to have to pay it. or if we get to publication and a senior lender comes in and forecloses in front of us and extinguishes our lien, then it's the HOA's bill. But publication in some cities can be $2,000. So what the UTA, which is the trustee industries trade organization, has helped promote SB 1148, which would allow us to not be forced in certain cities to only use city newspapers, but we could use a regional or a county-wide newspaper, which is a lot less expensive. So we're hoping that will pass. So there's some positive things that are happening, right? SB 2501. This is a problem. I'll start with a lower bullet point here that the author who wrote this bill admitted that the initial language is as a conversation starter, which is great, and that assembly person is open to amendment. The one right above that, though, there's potential issues with its constitutionality. So even if this were to pass, it's likely that it's going to be tied up in court. The problem with this, though, is the bullet point in the middle. It would prohibit the commencement of or continuation of any non-judicial or judicial foreclosure process for up to 2 years, because there's and also evictions, and evictions impact communities. If you foreclose on somebody, you wouldn't be able to evict them. So all of these things wrap up. 2501 is a big problem for us. And I know, Becky, you wanted to comment on a special issue that if this passed, it impacts your co-ops.
So with co-ops, you don't have the opportunity to do assessment lien foreclosures because there is no land to actually foreclose on or airspace that's deeded, because you have an occupancy and subscription agreement. So the way that all documents are written that I've seen for co-ops is you have to do an eviction process. So this would effectively mean you couldn't take any action against any homeowner for 2 years. And for some communities, it's going to be incredibly impactful. I have one that is, they're a senior community. They were already struggling financially. If this were to pass, it's going to greatly impact them, and it's going to make all of the other owners have to pay much higher fees because we won't have enough money in the budget.
So we at Allied, I try to send out constant contact email messages to our community, our professional community, when there's something meaningful. A couple of months ago, I sent one out that dealt with the federal legislation, and we even created sample letters that a board member could sign and send to their, or even email to their legislator. This is one of those times that if I were to reach out to you with a sample letter, it would be great if you could just print that thing out, put a stamp on it, and send it in. Because when they hear from us, the voters, and they're inundated with letters saying this is a problem and here's why, legislatures, they do pay attention. So we're paying careful attention to this one. Interestingly, it was up for vote already a couple of days ago. It had a certain level of votes. It didn't pass. And by the end of the session, it had actually reduced the number of yes votes. It is coming up for vote today, and I don't see that there's any text messages from our general counsel that it's passed. So we may have just passed this one and we can all breathe a little more deeply. But Allied is going to continue to monitor the legislative activity, and we'll send out notices. We'll let you know if there's something that really bears paying attention to. If we tell you, if I send you an email about one, it's probably pretty serious, and it could really have a negative impact on communities. And I try to limit the amount of email that I ever send out. So we've kind of been here before with some of these issues. We're going to take a look at a couple of case studies. Becky and I are going to really kind of breeze through these. You've got some bullet points. We're going to give a little bit more detail than the bullet points on a couple of slides. And then as soon as we're done with that, we're going to get to a checklist that Becky's put some work into to try to give you a takeaway. And that's that document that Rachel will be able to send out to you after the presentation, just if you want to have something in your hands to take to a meeting with your board or a staff meeting with your team of managers. Maybe talk through some of those items. So we want you to have some tangible takeaways. The first case study is a pretty recent one here in our office, having to do with requests for notice. The community had a long-established delinquent assessment lien for quite a bit of money. The owner was really adept at stall tactics, you know, and this case just went on for a very long time. The senior lender foreclosed and extinguished our delinquent assessment lien because they're senior to any other lien that's on that property. Well, the property went to a foreclosure sale. It like a lot of California properties, there's, especially in the past few years, we've had equity. You know, coming out of the last economic downturn, people were building equity again. So it was sold. They didn't just foreclose and keep the property because there was value in it. The bank knew it was worth more than what was owed. So it went to third-party sale. Someone bought it on the steps of the courthouse. So Allied does what we always do. We apply for surplus funds. So we know who the trustee is who's handling that foreclosure sale, and we have certain documentation that we go through to request the surplus funds. So the bank forecloses for this amount. This is how much the owner owes them. It sells on the courthouse steps for this much. So we've got a difference here. That's the amount of surplus funds. So we want this much of it, right? And any other lien holders can apply for surplus funds, or the proceeds go to the owner or former owner. The trustee denied our claim because the community had never recorded request for notice. And now the only option for that community is to go after the owner in Superior Court. So let's talk about what request for notice is. It is a recording in the county that the community files for, and it covers every door, a one-time recordation. It covers every door in that community, whether it's a community of 10 or 3,000 homes. It doesn't matter. It's the same file. It's the same cost. And I think Allied, our fee is a total, including the recordation fees and costs, it's $640 per community. That's a one-time fee. With that recordation, it attaches to title of every single APN in the community that if there's lender foreclosure activity, the association must be notified. If there is, and it requires them to record the transfer deed upon sale within 30 days. So the benefit to the association is, and for those of you like Becky who were around when there was crazy foreclosure activity in 2008, lenders would come in and you wouldn't even know that an owner, they may have moved out in the middle of the night. Nobody in the community knows who the new owner is. The bank certainly hasn't notified the association or the management company that they own you. You have no one to bill for assessments. And what they were doing regularly is they wouldn't record until they were ready to sell. And when they finally had a new owner, then they would record and transfer. And so for those months that the association doesn't know who owns it, you have no recourse except to try to take that institution, figure out who they were first, and then take that institution to court and pay. Highly unproductive, only sometimes successful. The association was just happy to finally get an owner in there who they knew and they could start billing. So request for notice requires timely notification to the association or management company that this foreclosure has happened and who the new owner is, and to record that TDOS. So those are important considerations, especially now. So when we look at what you can be doing now to avoid a problem like this, because Allied has certainly applied for surplus funds in the past, and if the trustee doesn't look for the request for notice, if they didn't think, oh, we should check, it's statutorily required, but if it isn't on their checklist, they just send us the money and we'd be very happy and we'd pay the community. Now they are starting to look more and more regularly. The RFN is required by statute for them to pay us, even though they have just been paying us in the past. So check your records. And if you don't have records on your associations, you can contact me. I'll send you a spreadsheet with all I need is the name of the community, their county. I need a sample address and an owner's name for that address. They don't have to be in collections. I just need to go look for an APN. Oh, and I need the APN. But once we have all that, we'll do the search and we'll tell you who's got the RFN on file. It's possible that the RFN of your community was filed by a previous management company. If Allied filed the original RFN, we can do an update for you. It's almost like a change of address. It's only a couple $100. But you really should make sure that those are on file. And I would consider stressing to put a priority on those of your communities that are large and or that had foreclosure activity the last time. And that's all I'll say about RFN. Becky, any comments before we get to your next case study?
So just make sure that you're having the conversations with your boards. Make sure that you're communicating. That's the biggest thing that you can do in this situation is you have to make sure that you're communicating. Hey, this happened years ago. You may not have been affected. We're looking at your delinquency report. It's growing. We need to look at this. We need to talk about it. And this is why you talk about it in executive session, to really have open and honest conversations and move forward with making sure that you're meeting all of the statutes so you don't get caught in an unfortunate situation where you don't get your funds and trying to chase down an owner.
We were fully expecting to get paid on this one, fully expecting. And it is just because there are the trustees, the various trustees throughout the state, there are many, they're paying more attention. We've been lucky in many cases that Allied does. We don't check to see if it's part of our contract, our Allied Advantage Service Agreement. On page 2, there's a checkbox. So when someone first onboards with us, we give them the option right then on their contract. Do you also want to do request for notice? Check the box. We'll do it right then with that management company on it. Invariably, those contracts come in with us. That box is rarely checked. And so we've been trying to educate communities, especially because the economy is looking the way it is. It really wasn't as significant 2 years ago. Now it's becoming important. All right, so now we've got, and I'm just checking on the time. We're just coming up on 12:30. I know our agenda time is for Becky and I to be on, including some Q&A time, until about 12:45. So we're going to get through these case studies and the checklist that Becky's have really thoughtfully created. We'll try to get through those in the next 20 minutes or so. Okay. So Becky, here's your first one, the Twilight Homeowners Association.
So I have changed the names of the associations and the homeowners to protect the guilty. So Twilight Homeowners Association, incredibly kind board. They had very passionate board members who are like, no, I heard about this situation. No, we just can't. We can't. Got to give them more time. Got to give them more time. Oh, I'm so compassionate. You know, I just can't do it. That was realistically what the conversations were at. This Mr. Moon, our gentleman, he went to collections in 2007. He hadn't been paying for almost a year. And because, oh, well, the collection fees are so high, we can't, let's wait a little longer. Rather than following their collection policy, okay, let's move it over. So they finally filed a lien in March of 2008, trying to give him extra time. He ended up going into a payment plan. They didn't have established guidelines, or, you know, we'll take everybody who wants to pay for 1 year, 2 years, and we're not going to go any further. We want to ensure that everything follows the same process so everybody is treated equally. It's not about someone's personal situation. Yes, you do take some into consideration, but that should be the exception, not the rule. You should put those into place. So they continued to delay. They actually didn't start the foreclosure process until May of 2012. So it started in 2007, and they didn't even get there until 2012. Well, because of all of this, well, now it's, we're now several years later, homeowner's going to go, well, I'm going to file bankruptcy. So the association got caught in a bankruptcy for 5 years, which can be extended if it's a Chapter 13. That's a payment and reorganization. And just as a reminder, you don't get to set how much you get from the bankruptcy court. The trustee says, here's the list of creditors. They're going to get payments in this order. So you may get nothing for the first few years. You may get $100 for the back payments. And this obviously added towards their growing delinquency in that community. So now we can talk about the actions. So we know all of this went bad because they just were too kind and needed to follow their collection policy. You have it in place for a reason. So what could have been done differently? Follow the collection policy. Adhere to deadlines. So when you're told it is time to move forward with the notice of default, you move forward with the notice of default, which is going to be a really tough conversation that you have with your boards. Boards inherently come from the people perspective, and they don't put on their business hat and go, okay, I'm running a business here. I've got to move forward and I've got to process things as I would as a business. They're coming from, Mr. Moon, he's my neighbor. I can't let him fail. It's, I see him every day. I talk to him. He's such a nice guy. Maybe they come into Age and they're like, hey, Age, he's an old man. He's 80 years old. We can't do this to him. You have to take that component out. Yes, you can feel compassion. Yes, as you can have a human discussion, but you have to follow the deadlines. You have to follow your collection policy, because if you're not following it for one and then treating somebody differently, you're running into a huge legal issue. You have to treat everybody equally, regardless of how you personally feel, because that person that you hate, maybe it's Bella. Oh, she's so annoying. She's constantly tripping and falling in the common area. I don't want to deal with her. Oh, she's got delinquency. Let's attack her. But then you're not handling Mr. Moon the same way because you don't like Bella, but you like Mr. Moon. That's where you're going to run into a problem, because they're going to say you varied from how your standard of care is, which actually brings into one of the questions that we got from Jack Edwards, and I'm going to touch on it. He said that when a payment is 5 days late after a 10-day grace period, he sends a friendly handwritten note asking, is there a problem? Can I help? Here's the thing. You have a collection policy. You are to follow the collection policy. If you're deviating from your collection policy for your association, you're in violation. You've set out the standards that you're telling your community, this is what we're going to do. And you certainly don't want to be sending handwritten notes identifying someone, hey, I know you may be having a rough time. Please don't, please come talk to me. People are embarrassed. Let them have their opportunity to come in and have that discussion if they want to have it. There's a collection policy in place, and part of the collection policy, as well as civil code, is IDR, ADR, and it's in your collection policy that they can come and talk to you. Don't go beyond what is stated in writing, because you're varying, and that runs into a huge problem.
I think, and there was actually a court case in California. An elderly resident received a friendly knock on the door from a board member to remind the elderly gentleman to pay his assessments. And he would write the check and hand it to the board member. And this went on for a couple of years. Then that homeowner was no longer on the board. There was no one who was knocking on his door. They foreclosed on him. The family sued. The family won because they claimed that he was discriminated against. He had come to expect a certain level of treatment, and then that ended, and the judge agreed. And so the house went back to the the elderly gentleman, and the association had to foot the bill for the legal costs. It was a challenging case. So I think Becky's point is a good one, is whatever your collection policy states, then stick to that. If the collection policy states that we're going to send a note, okay, because now any successive board member who replaces the one who's doing the notes is going to see that's the collection policy. We're responsible for doing this. If it's not in your collection policy, don't do it. And collection policies, the beauty of using your business judgment rule so that you can make decisions, you can treat cases differently if you have data. For those of you that utilize Allied, once we place the lien and you treat everybody the same on your collection policy and you get the lien recorded, then we send you what we call a collectability profile, which gives you a bunch of information about the property and the owner. And we're scoring, should you proceed this way, or this way? And then the board could actually treat 3 different homeowners who are all in debt, and we've placed delinquent assessment liens on all 3 of them. Now we have these collectability profiles for each. We can treat them differently. We have a large client here in the Roseville area that is a senior community. In reviewing with their general manager one of their collectability profiles for a 95-year-old woman, he looked at that and said, oh yes, let's just let nature take its course on this one. So they followed their collection policy and got the lien recorded like they do for everybody. But then at that point, they decide, we don't want to pursue foreclosure on this person. She's 95 and our debt is secured. Let's just sit tight on this one. Not to be morbid, but realistic. Becky, let's get into your second case study.
Yes. So New Moon Owners Association, they had a serious run of bad luck. The original developer in the community went bankrupt, had a ton of undeveloped lots, didn't have the funding to pay the assessments. So the developer said, okay, well, I'm going to sell it to Swan Inc., who the community...
Sorry.
It's all right. So Swan Inc. purchased about 60% of the community. They put themselves on the board. It was a 3-member board, and they decided to use association funds to pay their own staff, to do all kinds of things that they weren't supposed to. Association members, the other members, actually took legal action, got a court case, and ended up getting into a settlement. So they, the settlement, they're like, okay, we're protected. We got a court order, we have a settlement, we're good. We don't have to do anything else. That's not accurate. So here's the problems that they had. New Moon Owners Association didn't have a collection policy in place. And then once they did get one in place, they still didn't follow it and continued to allow Swan Inc. to be delinquent. Swan Inc. did not pay according to the settlement agreement, and the board took no actions till that community was at the point of bankruptcy. Swan Inc., when they got called to the carpet on their lack of payment, decided, okay, well, we're going to ramp up and harass other members. They harassed board members. They put derogatory signs on the back of vehicles and drove around the community. And now the members of the association had to bear the burden of 60% of the association. And these were single family homes. So it's not like, okay, well, we can work it out. So they made a lot of mistakes because they didn't have a collection policy in place. They didn't follow their collection policy. And, when it gets to the point of economic failure and your association is filing bankruptcy because they can't pay their assessments, you have a problem. And we need to talk about those problems well in advance. They were self-managed for a while, which is why they ran into this problem. And that happens with a lot of self-managed communities because this is not your day-to-day life. Us managers, this is our life. This is usually our career forever, unless you run away and win the lottery and move to the Bahamas. This is what we do. This is what we're passionate about. This is what we care about, is communities and making sure that they're taken care of. So what they could have done differently is they could have talked to their legal counsel. They had an attorney. They obviously knew that the settlement agreement needed to be followed up on, but they didn't do that. They needed to make sure that they had all of their governing documents in place and that the governing documents had correct names, correct information, all of that. They should have contacted a reputable collection firm as soon as they got the settlement agreement and he started defaulting. And they need to talk about member engagement. That's one of the biggest things that you're going to have an issue with is members put a lot of burden on board members. So they stay and stay and stay, and then the board members get burned out and then you have nobody. So just make sure that you're talking and fostering engagement with all of your community members, not just, the board members. Talk to everybody. Try to get everybody to join the board.
Wouldn't it be amazing if you had too many candidates for the board?
That would be awesome.
That happens. Yeah, probably doesn't happen that often. We've got a few minutes left, so I'm going to whiz through a couple of slides because I'm sure some of you have some Q&A, and then we can turn your cameras on. You can all socialize with each other. Let's see. Oh, this was an important thing that I want to stress is that even CAI at the national level is making recommendations. If you haven't seen them, I attached them to a constant contact message that I sent out to our client group in March or 1st of April. Significantly, CAI is stressing, record the lien to protect the HOA. So even while we're looking at practicing compassionate leniency or Becky, your grace and space, paying attention and caring for the members in your community. And one of the biggest ways of doing that is by waiving late fees and interest charges, because remember, as Becky's wagging the finger, hopefully your community is not counting on late fees and interest charges as part of your income to do your budgets. But get that lien recorded. At least you've secured the debt so that at some point in the future, as whatever state and federal rules may be impacting our ability to foreclose, at some point that owner may just sell that property and at least we can recover with that escrow demand. So stick to the collection policy, get the lien recorded, practice compassionate leniency, and encourage workable payment plans. When associations work with Allied, oftentimes the debt that comes to us is let's say 12 months old. And the board they want a 12-month payment plan. We want that guy to pay up in 12 months. Well, if the guy's already having a hard time making his regular monthly payment, if we set him up on a payment plan, which includes his ongoing assessment and 1/12 of his one-year-old debt, he's now paying two assessment of payments every month. 12-month payment plans are almost unworkable if the debt is a year old. It's just so much money. So Allied typically asks for pre-authorization to set up 24-month payment plans, just because we find they're at least workable. We want to come up with a payment amount that your owner can actually pay. We don't want them defaulting every 2 months and having to maybe see if they want to do a new payment plan. We'd like to come up with a payment plan that's manageable. And so for boards that are resistant to anything longer than 12-month payment plans, now is the time to reconsider that position. What can I do to protect my community? So see the note here, this is the checklist that Becky's helped come up with and that we can send out to you. But just to go quickly through these, evaluation and discussion of the financial health of the community. This is critical. Where are we now before things get worse? Are there major projects that we've budgeted for that maybe we ought not have right now? And with shelter-in-place orders, you may not even be able to get the workmen on site to do the work. So those things may be delayed, which ties into Becky's point about the reserve funding. You're looking at current delinquencies. What kind of bankruptcy activity do we have? Can we expect that if we've got a Chapter 13 payment, that we might be seeing less of it because of the change in the bankruptcy allowances for Chapter 13? Are your liens recorded? If you've got some files that boards have been sort of sitting on, not making decisions, get them off the fence and get the liens recorded to protect the fiscal health of the community there. And Becky's got her co-ops listed there again. I know that's your passion project, so put in a plug for your passion project there.
So make sure that when you're looking at your cooperatives that you are looking at their financial health in a little bit different way, because you don't have the ability to foreclose right now during the pandemic. Well, you can't foreclose, you evict them. So be prepared that this is going to be a little bit longer, and if you don't have the funding, make sure that you're looking at your funding really carefully with co-ops.
All right. Establish a written plan of compassionate leniency. So this goes back again to Becky's comment about grace and space. We talked about payment plan terms. We've had a healthy discussion about, well, I've had a one-sided discussion about request for notice and its importance. Again, this checklist will be available to you afterwards. And we're just coming up on 12:45. Once again, there's our contact information for myself and for Becky. Thank you from me, Becky.
Thank you so much, everyone. And honestly, if you have any questions, please always feel free to reach out to either Stefan or myself. We are very passionate about collections, and this is one of the conversations that we like to have. So if you have questions, I'm happy to help. I know he's more than happy to help.
And Becky, we got through all of our slides by 12:45.
I know, I'm so happy.
I had a little bit of caffeine today, and I don't usually drink caffeine, so. But I do get paid by the word, so this is the best day for me.
Well done, you guys.
Thank you guys.
Thank you.
Very much. We appreciate it.
Okay.
We do have some upcoming programs we want to tell you guys about. We have another digital education program coming up on July 16th. It's going to be advanced risk management. That will be again via Zoom. So we hope to see everybody here for that. In addition to our sponsors and our speakers, I'd like to take a minute to just give a shout out to our amazing executive director, Rachel, because she has done such an awesome job of putting all of this together for us, getting these virtual programs up and running, and she's just done an amazing job. So I wanted to take a minute to give her some.
Thanks, guys.
You're awesome, Rachel. We love you.
You're pretty awesome. Also, very exciting news. I heard about this morning, and it is on my list here to share with you guys. We have a digital legislative day coming up. So we missed our ledge days at the Capitol. They were scheduled right at the end of March, right when all this COVID stuff happened, and they kind of got canceled at the last minute. And I know a lot of people were disappointed. So that is coming up. We were not able to hold our Corks for Clack event, which was also a very sad day for all of us. But we are coming up with something, so mark your calendars for Wednesday, August 12th at 2 p.m. We'll be sending out more information as it comes along, but we are trying to put together a digital legislative day. So that should be absolutely amazing. So thank you all very much for attending today. And
We do have a question.
oh, I have questions and answers. My bad.
So, okay, we have one question. Are we required to file a new lien every year on accounts with liens present?
No, there's not a requirement. If you'll think back to when I was talking about that Ninth Circuit Court of Appeals case, it's important if your delinquent file owner declares Chapter 13 bankruptcy. If that's the case, and your lien is for $2,000, and you recorded it years ago, and now his debt is $15,000, if he declares bankruptcy, the bankruptcy trustee is only going to pay you on this. That's it, and all of this difference here, that's out. So it's important to talk to whoever your collection provider is, and analyze those files that you have that are old and or have a high balance differential between what's owed now and what was initially recorded. And there are some collection companies that they're filing new liens every single year. And yeah, the judge said, yeah, that's going to be a problem. We don't think that's a good, that's adding so much debt to the owner's account. That's not how we operate. We're going to place a lien if we all agree that, yeah, this one's kind of at risk here. We should probably stick another lien on this one. We think that's better business. And we think it's better for communities with neighbors.
We're a community.
Stefan, sorry about that. I totally cut off the question and answer section.
All right.
That's okay.
So Rachel, I'll let you take the lead. Are we ready for everybody to unmute and come
All
up?
right. Yes, we're getting also a lot of thank you to the speakers in the chat. So speakers, go ahead and check out that chat. And if you want me to save it and send it to you for like a little kudo board, I totally will, because it's a lot of like nicely done, great information. So we really appreciate you. Thank you so much. But if everyone